calendar for argument this morning.
Thank you, Your Honor.
Spurlin versus Foster Wheeler. Mr. Hugo.
Good morning. Edward Hugo for Foster Wheeler. I will address two things with the court's permission. The consumer expectation test first, but I'd like to go back, and it is mentioned in the brief, and talk about the applicability of the consumer expectation test. It's Foster Wheeler's position that the consumer expectation test is not at all applicable.
Well, the reason that I focused on the context of the way it came up is I'm not sure you're right about that. So let me pose you a hypothetical of the consumer expectation test. I expect as a pedestrian that big trucks will have backup lights and backup sounds. And I walk behind a truck that has no sound and it hits me. I didn't buy the truck, but the case law seems to suggest that the product can be considered defective under a consumer expectation test because I'm, as the injured party, I would have a right to assume that it was made in the way that most other products were made. So I'm not sure you're correct in saying it is only the buyer of a product that can invoke the consumer expectations test.
Okay, so the case that they cite on point is Soller, and what Soller says...
They may have cited the wrong case. I'm saying I think this is what the law is on that topic.
Right, and I'm with you 100% on the question. Soller indicates that the consumer expectation test is inapplicable, quote, when the ultimate issue in design defect calls for a careful assessment of feasibility, practicality, risk, and benefit.
That's a different argument, though. See, I think their non-made objection. Their objection is to when you say the consumer expectation test is inapplicable to somebody like Mr. Spurlin because he didn't buy the product. I understand your argument that you win on the consumer expectation test because this was designed to the Navy's specifications. But that's a different thing than what he's objecting to.
You're exactly right, and if I can use the analogy, that was two ships passing in the night. I'll be with you for like another 12 minutes. So, with regard to your question, which now I understand, yes, there is an argument that somebody like Mr. Spurlin would be the person who benefits from the consumer expectation test, just like the Navy does. So your statement with regard to that is correct. What I was saying, it didn't convey, is this test is not applicable at all for anybody, period, because a Navy warship is not a product. I argued the McIndoe case to this circuit in 2016 in this courtroom. We have a Navy warship that's not a product. Now, the question is, if you don't have a product, how can you have a consumer expectation test applicable when the ultimate issue of design defect calls for a careful assessment of feasibility, practicality, risk, and design? So in our case, the Navy not only designed the warship, the Navy designed Foster Wheeler's boilers and all component parts of it. There is not a single person on the planet who would think that a Navy boiler is, quote, an apparently innocuous product, close quote, which is the quote from, again, the Soller case talking about a piece of insulation. This is the heart, literally, of the ship that's in evidence. It's so big that the ship is built around it. It's 2 stories of a pressure vessel that could explode, catch fire, kill people regularly. If there's a steam leak and you walk past it without seeing it with your hand open, it'll cut open your hand and cut off your fingers. It's loud, it's hot. It's basically a bomb that has to be tended to 24/7, 365 when it's on. How can an ordinary person have an understanding of the safety of that? They don't, which is completely different than what you were saying, and I 100% buy your analogy. If we're living in this world and walking across the street, you should be able to think that somebody driving your car should have lights on at night, or you should have one of those beep, beep, beep. Corey's going to love that. When you're backing up, that's ordinary. Whether you're an ordinary juror, an ordinary person, an ordinary bystander, the consumer who purchased it, everybody's got that understanding.
So what I'm trying to find here, and I'm not very good at it, what was the supposedly offending argument that you made? Now,
That
because
I-
there's no objection to instruction, what did you say?
That I said the Navy was the consumer of the boiler, because the Navy is the one that designed it, had specifications that were so specific that it required the incorporation of asbestos materials in it. The Navy inspected the boiler at Foster Willis facility when it was being manufactured, at the Navy Yard when it was delivered, installation on the ship, sea trials, and commissioning. And they did the same thing with regard to the manual that came with it. There were specifications for the manual. Drafts had to be submitted to the Navy. The Navy had to actually approve the manual. So everything that was sold by Foster Wheeler was sold to the Navy pursuant to their own specifications. And in this case, let me remind you that this was not even Foster Wheeler's design. The Navy required Foster Wheeler in World War II to produce a Babcock and Wilcox boiler for the purpose of putting it on this Rowan, because they wanted all of this class of ships to have the same boiler. So they're objecting that I said the Navy was the consumer. They took the position that Mr. Spurlin or other seamen would be the consumer. As you pointed out, they never, ever gave the judge an instruction to that effect, so they waived it to begin with, and then it became argument.
I take it that there's no dispute between you and the other side that we don't get to the superseding and intervening cause instruction unless there's some other error in the case?
That is correct. I'll submit on Judge Pataglia's exclusion of the other transcripts under 403.